So in this video, I have an update in the California rifle ban case called Miller versus Bonta. The Supreme Court's recent statements in a 9-0 unanimous decision are now being used in support of striking down the state's rifle ban. So let's break down what just happened. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. They have great supplements, protein powder, pre-workout that I use, as I'm trying to get healthier and work out some more. But also one of the cool things about 1st Phorm is they are pro-freedom, pro-America, and they support the Second Amendment and what we talk about here on this channel. So if you want to get great supplements and support a great company, check out 1st Phorm using the link down below. And if you order something $50 or more, you can get a free 4-pack of energy drinks. So as I mentioned in the intro, in this video, we're going to be talking about the Miller versus Bonta case, which is a challenge against the state of California's ban on so-called assault weapons. This case was recently argued in front of a 3-judge panel in the 9th Circuit. And this case has been pending for a long time and has made its way to the 9th Circuit a couple times now. And again, this revolves all around whether or not the state of California's ban on rifles is in fact a violation of the Second Amendment. This case was stalled for a while, but since the 9th Circuit en banc panel finally decided to rule in the Duncan magazine ban challenge, this case is now moving forward. And interestingly, in this case, the recent Supreme Court 9-0 unanimous decision in the Smith & Wesson case, which deals with the PLCAA, that is now being used in support of this challenge in why the rifle ban should be struck down as unconstitutional. That recent ruling by the Supreme Court included statements by multiple Supreme Court justices essentially outlining that AR-15s and similar types of rifles are in common use for lawful purposes and therefore cannot be banned. Now, for those not aware, the Miller versus Bonta case is a challenge to the state of California's ban on so-called assault weapons. Under California Penal Code Section 30515, the state of California bans various types of firearms based on their characteristics. For example, a semi-automatic centerfire rifle with a detachable magazine cannot have something like a flash hider, a collapsible stock, a forward vertical grip, and if it has any of those characteristics or features, it is defined as a so-called assault weapon in the state of California. This Miller case was originally heard by lower court Judge Roger T. Benitez, or St. Benitez as he's known, and originally on review this case, Judge Benitez determined that the ban is not in line with the text and history of the Second Amendment. Therefore, he granted a motion for summary judgment in favor of the plaintiffs which were challenging this California ban. After his original decision in this case, California then appealed up to the 9th Circuit. A 9th Circuit 3-judge panel did grant review to this case, but then the Miller case sat pretty much on hold. It sat there in the 9th Circuit for a while because the Supreme Court was reviewing a backlog of cases, including the New York State Rifle and Pistol Association versus Bruin case. Once the Supreme Court issued the Bruin decision, this Miller case, along with a bunch of other cases in California, were sent from the 9th Circuit back down to the lower court judges. So Judge Benitez got review of this case. Once again, he had to re-review it in light of Bruin, but once again, he ruled the same way, finding that this California ban is not in line with the Second Amendment and it violates the text and history of the Second Amendment. But again, after that, California decided to appeal to the 9th Circuit. It went to a 3-judge panel once again in the 9th Circuit, and that's where it currently sits. But what ended up happening is essentially the Miller case, again, was put on a holding pattern. It was sitting behind the Duncan magazine ban case that was being reviewed by the 9th Circuit en banc panel. They heard oral arguments in that Duncan case, but then that sat for about a year. And so Miller also sat for about a year. However, recently we know that the 9th Circuit finally decided to rule in Duncan. They've upheld the Duncan magazine ban. They said that California's magazine ban did not violate the Second Amendment, and that's currently also being appealed and is seeking Supreme Court cert. Now, after the Duncan case was heard once again and was finally ruled on, the Miller case was activated once again, and back in January, the Miller panel finally heard oral arguments in this case. Now, listening to those oral arguments here in this Miller case, you could tell how biased judges like Berzon and Nguyen were against the Second Amendment. Multiple times they called AR-15s machine guns, or even just, misnamed them. They called them A-15s. And they had really no technical knowledge about what these firearms actually were, how they operated, and how commonly they were actually used for a lot of purposes like self-defense and, target shooting and training and all of that. Now, Judges Berzon and Nguyen stated multiple times that the common use test outlined in Heller and Bruin were circular, so they did not agree with the Supreme Court. Judge Nguyen even went so far as to challenge the statistics that there are millions of AR-15s and other semi-automatic rifles that are in possession by millions of gun owners across the nation. In fact, at one point during the arguments, they tried to argue that maybe the numbers nationwide are high, but they were saying that, California gun owners themselves do not own them in high enough numbers for them to be in common use. Now, since those January oral arguments, we've been waiting to see, how this would develop and what the Ninth Circuit would do in this Miller case. But recently, this month, the Supreme Court issued a 9-0 decision in the Smith & Wesson case. And in that decision, the court included language stating that AR-15s and similar rifles are in common use for lawful purposes. This pushes back against those very arguments and statements that were made by Judge Berzon and Nguyen during the Miller oral arguments. And the plaintiffs in Miller just submitted the Smith & Wesson language as support for why the Ninth Circuit should find that AR-15s and similar rifles are in common use for lawful purposes and cannot be outright banned by the state of California. In this supplemental brief, the plaintiffs here state that in Smith & Wesson, the Supreme Court rejected Mexico's arguments that firearms manufacturers aided and abetted unlawful sales of firearms to Mexican traffickers by making the design and marketing decisions to manufacture military-style assault weapons, including AR-15s, AK-47 rifles, and .50 caliber sniper rifles. The Supreme Court unanimously held that the arguments failed because those products are both widely legal and bought by many ordinary customers. And there they state to the Supreme Court that the AR-15 is the most popular rifle in the country. Because these statements were necessary to the result of Smith & Wesson, they are not mere dicta, but rather binding authority. As plaintiffs have explained, the Supreme Court has previously concluded that arms in common use are categorically protected and cannot be banned, consistent with the Second Amendment. Given the legal principle, the Supreme Court's binding conclusion that AR-15s, AK-47s, and .50 caliber sniper rifles are bought by many ordinary customers, and that the AR-15 specifically is the most popular rifle in America, make clear that they and other similar arms, which California groups them, are categorically common and cannot be banned. So although the panel heard oral arguments and stated during those arguments that they do not believe these rifles are in common use for lawful purposes, now there have been multiple decisions since those arguments, including statements by the Supreme Court in the PLCA Smith & Wesson case, outlining that very clearly they are in common use for lawful purposes and that they are the most common rifles owned by law-abiding people. If the panel wants to uphold California's rifle ban, they will have to outright reject these statements made by the Supreme Court or try to twist them or distinguish them, saying that, this is a PLCA case, that this is just dicta, it's not binding on us. And we know that the Ninth Circuit has a track record of just outright defying the Supreme Court or just trying to ignore what the Supreme Court has said in cases like Bruin and Heller. And as of right now, the Supreme Court really has not stepped, in to correct any of this. They've rejected multiple reviews of rifle bans and magazine bans. They've not corrected lower courts. So lower courts like the Ninth Circuit have felt emboldened to continue to defy what the Supreme Court has said. There's also an added wrinkle to this Miller case to where if the 3-judge panel here in Miller does not want to review this or even have to write an opinion defying what the Supreme Court has said in the recent PLCA case, essentially what they could do is they could try to just stall this out even further, say that, they're going to continue to hold Miller and not issue an opinion until the Supreme Court decides what they want to do with the Duncan magazine ban case. Like I said, the Duncan magazine ban case was ruled on by the Ninth Circuit en banc panel, and currently a writ of cert is being sought to the Supreme Court. I believe that's going to be actually filed July 18th by CRPA. So once that is filed with the Supreme Court, the Ninth Circuit here could say, we're not going to review Miller. All along, Miller has tracked along with Duncan. We believe Duncan will impact the outcome of Miller, and so we're going to continue to hold Miller until the Supreme Court decides what they want to do. In general, I think it's going to be either the 7th Circuit's Illinois PICA challenge or the New York rifle ban in the 3rd Circuit that will ultimately make its way to the Supreme Court first on the final merits. The 9th Circuit has slow walked the Miller case all along, so I think one of those other cases is going to make its way to the Supreme Court first, or we're going to have to wait for the Supreme Court to rule in something like Duncan to correct all the stuff that's going on in the lower courts. We have some positive movement in this, but again, the 9th Circuit can continue to defy the Supreme Court and stall this out for as long as really they want. So that's what's going on. As we get more information, as this further updates, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.